senior officers and colleagues, dear friends. It's been, I think, third or fourth time I'm coming back to NACIN after taking voluntary retirement about 1.5 years back. This topic was quite to my heart, and he said, would you like to title it as Demystifying Adjudication? But no problem, Demystifying Adjudication. You know, the word adjudication and the show cause notice, for you it is not a mystery. For you who are adjudicators, for you who are departmental officers, who are day in and day out passing adjudication orders, it is no mystery. The mystery is for a person who receives it. Person who receives a show cause notice, you should see his mental condition. I mean, now I've been seeing it even when I was in department, and now more so. I'll give you a very recent example. There was a superintendent of mine in Custom House, very popular superintendent, and quite a tough one also. After retirement, I think he started some travel agency or something with his wife's name, and they missed out some payment of some service tax. It was not a commission, it was more of a omission. And a demand was raised, and he received a show cause notice. The kind of tension that I saw in him was unimaginable. He came to me and said, "Sir, somehow it has to be, you have to help me out." I said, "You have been seeing show cause notices, you have been handling, you have been serving, or you have been investigating for so many years, almost 30 years. What is so, yes sir, it is very tough. I don't know what will happen. Penalties they have invoked all clauses in penalty. About 12 lakh rupees demand is ending up at around 35-40 lakhs liability if it is confirmed. So you have to." Of course, we handled it and we could place facts on record, and something happened. He could solve it in some way. The point which I am trying to make is that demystifying is for whom? If it is for you, then the only thing that comes out is that you have to be fair. The adjudicating authority has to be fair. If you are fair, I can conclude the topic in maybe one sentence by saying that what is written in Bible, that you don't do unto others what you don't want to be done to you. So if that philosophy is adopted in adjudication, then there will be no problem. Now the thing is that you are all vested with authority. I'm sure you know the difference between power and authority. Power being what it is. I mean, even a gunda has got power, he can make me do something against my will. But as an authority, you can do the same thing with the sanction of law. Now, when sanction of law is the thing which gives you the power or makes you an authority, then it becomes incumbent on you that you exercise that power in a manner that it is transparent, and the person on whom it is exercised understands it and agrees with it. Just because you have the power, you cannot arbitrarily or irrationally exercise it and put him to discomfort. Now, your demand may be just. The demand made on the person may be just, on the taxpayer may be just, everything may be correct. But he has to get convinced that the demand which is being made, the demand which is being raised, the penalty which is being imposed, the things that, the prosecution that is being launched on him is as per law, and nothing has been done against him which is contrary to the provisions of law. And that is where the whole adjudication stands. And that is where the whole thing has to be demystified. Now, mystification or demystification of adjudication is very important for you because you are at the giving end and the receiving end person should understand what you are doing. Therefore, the most important thing is two things you please understand as adjudicating authorities: accountability and transparency. Now, accountability is that you are accountable to the law that you are enforcing. You don't have unfettered rights about anything. Nobody has got unfettered rights. For the simple reason that we all work under a constitutional scheme, and rule of law is the basis of our any action. Now, any action that you take has to be justifiable. You must be able to justify, this is why I did this. You do anything. Nobody is saying you don't do this, you don't do that. But at the end of the day, if you have arrived at a classification, if you have arrived at evaluation, if you have arrived at asking him some letter, I mean, you must be able to justify based on the law that you are exercising, that this is why I did this to him. This is why I asked him to do it. That is all is adjudication. Now, adjudicating authority is defined. If you take all our laws, if you take central excise, service tax, I don't know what service tax, central excise, customs, even GST, adjudicating authority is defined, but not adjudication. What is adjudication? Anyone can make an attempt. Let us make it little interactive. Adjudication, I'm supposed to talk on demystifying adjudication. What is adjudication? Anybody? Make an attempt. Pardon? To adjudge a dispute. Okay. To adjudge a dispute. Correct. Then anything else? Adjudication. You all do adjudication. Pardon? To render justice. Okay. Then to render justice. To adjudge a dispute. To render justice. Anything else?
The activity of settling the disagreements.
Okay. So, activity. Activity. You can improve the word activity.
The process.
Yeah, process. Process of settling a disagreement or dispute. Okay. Anything else? So, by and large, we have 2 or 3 responses. 2-3 things come out very clearly. One, where there is no dispute or disagreement, there is no adjudication. Need for adjudication. There is no need for adjudication. Where there is a dispute or disagreement, there is a need for adjudication. Now, there are 2 ways to look at it. One is that the taxpayer may be right and the department side or the adjudicator may be wrong. So, the adjudication order should lead to dropping of proceedings. Am I right? If the department is wrong, then you don't continue with the adjudication, you drop it. If the adjudicator or the department is right, or his contention is right, the demands are right, then you confirm it. But there is something involved which has been stated by him and the gentleman there. There is adjudging a dispute or a process. Now, the adjudication entirely concerns about a process. It is the process which is sacrosanct. It is the purity of the process, the transparency of the process. That is where the need to demystify it lies. You cannot have an adjudication in an opaque manner. You cannot pass an order just because you are an adjudicating authority. Your being an adjudicating authority cannot lead to an arbitrary adjudication. It has to have a process, and the process should be pure the process should be transparent, the process should demonstrate that you are equally interested in rendering justice and showing that the justice is being rendered. It is not that you pass an order and forget about it. It is not a one-way traffic. So that is where the problem starts. The problem with human beings is that, whether knowingly or unknowingly, we internalize our positions, our powers, our authority, our everything, and we tend to exhibit it in a manner that is adverse to the other person. We may not be deliberately doing it, but the sheer fact that you are holding a chair, you are sitting in a chair, the person has to knock and come, he has to stand till you tell him to sit, or you may not even tell him to sit, gives you a position where you feel that any action taken by you is correct. It is not. You are bound by law to show that the action taken by you is not only correct, and you have to clearly state in that many words through your order that it is correct and pure. You have to, it is like explaining to the person, explaining to the taxpayer, this is why I have raised this demand. This is why the offense which you have committed has been recognized and your goods are being confiscated. This is why the penalty is being imposed. Now, this process is the whole universe of adjudication. And unless you understand this, it will be very difficult for you to demystify it or do anything with adjudication. You may be adjudicating authority, you may be passing adjudication orders day in and day out. But how far you are able to make up your mind, it's a mind game to a large extent. That I am a judge today, I am not executive. The whole thing about quasi-judicial function of any tax administrator is that you are part administrator and part judge or a judiciary. You are not judge in the sense of term that you hold a court, but you adjudge disputes. And while doing so, you have to behave like a judge, and you have to bring in that kind of transparency and that kind of elements in your function, that there is no opaqueness or there is no darkness in the minds of the taxpayer. He understands why you have done it. It is the process of convincing. It is process of convincing the taxpayer that you are not being given a raw deal. You are not being made to suffer for no reason. You are being, whatever is happening to you is as per law. This is all is adjudication. And when there is no dispute, there are now what you call as systems in place. For example, the cases which don't involve offense, there is a pre-show cause notice stage where you consult. So what is important is, the most important thing is, it is not us versus them. This one notion, if you can remove from your head, that it is between the department and the assessee, department versus the importer, department versus the taxpayer. This versus business, if you remove from your head, half the problem is solved. You are not against the taxpayer. Your job is not to be against the taxpayer. Your job is to collect the tax. Your job is to administer the collection of taxes. Your job is not to be against. And this one particular thing leads to so many things, so many other issues. I can tell you a small thing. Now you go for a raid, or you go for a search or anything. You resume or you collect so many documents, data, computers, hard disks, I don't know what all. The general tendency is to simply load everything relevant, irrelevant, and bring it. And you start sifting based on the kind of case that you are looking at. You sift the data, you segregate the data, you try to make out what is relevant, what is not relevant. After that, you prepare a show cause notice, and then in that you add relevant, relied upon documents, RUDs. Now there is a whole bunch of things which you are not relied upon. Maybe the truth is hidden in that. Maybe something is hidden in that which is totally contrary to your assumptions, totally contrary to your premises on which you have built up the whole case. You don't want to add it. You don't want to put it and drop the case. You don't want to say, no, we have found evidence which is contrary to our assumptions or our starting point, and therefore there is nothing to proceed against. No, you will not. You will still suppress those documents. You will bring out only the documents which are in your favor. You will give a huge show cause notice. Aggressive demand. I was aggressive. The word used by Mr. Kannan was aggressive. You will be hyper aggressive. Where there is a small demand of say 6 months or 1 year, you will make it to 5 years, and this is us versus them. This is us versus them. We are not here to do us versus them. If we have, if you are really a good tax administrator, there cannot be a dual match. There is no boxing match with them. Everything has to be decided on the basis of evidence, what we have collected and what we are showing it to him. Even the charter, our citizen charter used to say that the documents which were not relied upon should be returned. Do we do it? I will tell you a case, quite a big case. This happened in customs only, huge smuggling case. Now, whatever was seized, the goods which were seized, that case was fairly watertight. It was open and shut. But they went back. They said all imports which happened by that importer for last 3 years or whatever it is, and they inflated the whole thing. Now they had seized so many documents, so many hard disks, etc. The information which was there in that was not given to him. He kept on writing to the adjudicating authority that please supply me with this information, not given. He went to High Court. High Court said you give it. They didn't have it at all. Either it was lost or whatever has happened. This went on for almost 9 to 10 years. At the end of 10 years, the High Court quashed that show cause notice, saying that you are not following anything, not following the principles, you are not giving the documents, neither are you adjudicating, nor you are doing anything. Yeah. Now you are filing appeal against that quash. No, it is all because of the syndrome of department versus citizen. If the idea of department versus citizen is there in your head, then there is no question of demystifying anything. You will remain a feudal lord, you will be the boss, and they will be the recipients of your justice, and whatever they receive, they will keep on going, I don't know, wherever it takes them up to Supreme Court, and things will keep going round and round. Somewhere you will have to accept that we are all creatures of law. This is the first point to demystify adjudication.